All right. Well, first off, welcome, Kayla, and welcome to everybody who is attending another live episode of the Andrew Hines Real Estate Investing Podcast. So this is something I'm doing roughly once a month, just trying to get live guests where we can do some Q&A and really dig into questions that people have, because I don't always have the same questions that my viewers and listeners have. So, Kayla, you are the founder of Ontario Landlords Watch and a landlord yourself, but I don't know too much of the story. So before we dig into any sort of presentation or kind of content that you have for tonight, why don't you just tell us a little bit about yourself and your experience?
Okay, well, we're live, so I can't mess this one up, right? So you're right. I've been a landlord for 18 years. Started really, really young, having a young family and renting ourselves as we were homeowners. I got into advocacy in 2010 with one of our rental properties. It was a fiveplex, and the city of Cambridge made landlords responsible for their tenants' delinquent utility bills. So that is when I started to challenge the municipal government and also challenging the provincial government with petitions trying to stop such a bylaw that was going to be pushed through in order to make landlords financially responsible for another person's debt. We got a petition happening that went across the province, and of course we got a change of power, kind of set us back a little bit, but it was a good way because what happened is that through this petition, we had so many landlords sign it and send it back to us with notes and letters and comments about, hey, this is great. Can you also fight the Residential Tenancy Act and the Landlord Tenant Board? So back in 2010, this is when we got started with really analyzing the issues with the Residential and Tenancy Act and the Landlord and Tenant Board, and really coming together as a solution, as a team, creating these solutions. And when I bring everybody together into Ontario Landlords Watch members' Facebook page, it's a way for us to really get involved, be able to educate them on what is happening in the industry, get their input and their feedback, so I can take that back to the meetings when we do have consultations with the elected officials or the Landlord and Tenant Board. And as of a year ago, became a property manager in the city of Cambridge, Kitchener, Waterloo. And then as of March, I became the National Ambassador to Landlord Credit Bureau. And also sit on a city committee in order to address the affordable housing and homelessness within the region of Waterloo as well. So been busy, also got 4 kids. So.
You're doing a fair bit. I don't want to breeze over the fact that you were kind of identifying that the Landlord and Tenant Board heavily seems to favor tenants in Ontario. Would you agree with that statement?
100%.
And why do you think that is? I mean, we don't have to get too deep into it, but what is it about that?
Well, it's all about politics, right? I think that we're looking at the concept that when you are removing someone from their home for non-payment of rent, what's going to happen is that the people are now going to be ejected from their home, and they now become a problem to the municipality, to the region, or to the province. So this is obviously going to be costly on taxpayers as people get evicted. So again, they don't want to be utilizing that. They don't want to be putting that type of pressure on the municipalities, because they're already strapped. We have waiting lists for government housing that is beyond 10 years in the region of Waterloo and 22 years in Mississauga. So in reality, what they do is use small landlords and even big landlords as social agencies for the government in order to house people who are just abusing the system.
Yeah, there's obviously a lot of abuse going on, obviously some nice intentions there, but a lot of abuse as well. Right now, we're kind of in a peculiar situation, and I don't know if you want to just dive into the content you have, and we can ask some questions at the end. Like, what did you have in mind here?
Honestly, this could be a back and forth. Like, you ask the questions, I'll give you what you need. Because even when I'm presenting with the elected officials, we start off with, why Ontario Landlords Watch was created, why they need to listen to what we're recommending, and how we can work together. But just fire them off at me, because I know we had a quick chat over the phone of, what I do and how I do it. So I want to give everybody an update and give them some tips and tricks and how to balance and battle a tenant that is obviously being difficult through these difficult times.
And we're going to get into some case studies. I'm sure I actually had some people send me some questions via email before. I asked them to come back here and post their questions here. So if you do have questions, everyone, just go to the Q&A box at the bottom and type the question in there. Otherwise, if you put it in the chat, we might miss it. So go ahead. You can post them anonymously if you don't want your name attached to them. But by all means, get those questions in there, scenarios, whatever it is, so that we can talk about it. Because if you got these questions, other people are going to have these questions too. My main question is, what is notably different right now from usual? So why don't we start with that one?
Well, one, we look at the concept that there is a major backlog. It's been happening for quite some time. The Landlord and Tenant Board is trying to address the backlog. We do have the Ontario Ombudsman actively investigating the Social Justice Tribunal. That has been going on for quite some time. We are now giving them the last few weeks to kind of pull their socks together, because we need to start calling on the Ombudsman to come out with their report on the Social Justice Tribunal. Even though we find that a lot of hearings are starting to get heard, we still have a problem where landlords are not getting their orders. They're not getting their judgments of what they've decided for a very long time. But that gives us good news that the Attorney General is planning this system that is a new digital case management system of Ontario 14 adjudicator system. So this is it's going to model what BC's doing. They talk about how it's going to be accessible 24 hours a day. And between the Landlord and Tenant Board and the Human Rights Tribunal, these are the most busiest tribunals in Ontario. They feel that they're going to have more dispute resolutions. They're going to be able to speed up that process, and they're going to be able to, prevent cases from having to be heard by an adjudicator. Now that's supposed to be hitting, the changes are going to start happening in the summer, and it's going to be fully implemented by December of 2023. So that gives us hope, and that's great. But again, we have landlords suffering now. We have tenants suffering. This is about the system, the housing market, and as a whole is under a threat. And I think what you'll start to see that, what's always been happening is that non-payment of rent has been the #1 application at the Landlord and Tenant Board. And we also have the concept that we have more landlords doing N12. So N12s is taking over the unit for your own personal use. And they have become very, very popular within the Landlord and Tenant Board, and as well as our paralegals who are doing the paperwork for that. And, some are realtors, they're trying their hardest to do this N12 and have their case, but it's also causing their deals to fall through because the tenants are refusing to leave. So that's what the current changes that are happening, which is, I love the fact that we are going digital first, but not digital only. Many tenants are trying to stop that because they feel that it's not giving them access to justice and fair representation. But again, they have lots of time to get legal advice. They do have the option where I feel it's easier for tenants to be heard and show up at their hearing versus having to travel to a place like ours in the region of Waterloo was actually at 2 places. It was in a community center with the pool below you, and they now have changed it into a hockey arena. So it's like, that's not really quite a nice place to have your eviction hearing, but they have changed it, and it's great to know that it is gone from Microsoft over to Zoom.
Okay, so, I probably should have started with this, but just like high level, because a lot of people aren't familiar with this process. I know you're in it every day, but say I'm a landlord and I didn't know what I was doing. I have a tenant in my unit, and maybe that tenant's not paying or exhibiting some behavior that, maybe in your eyes would justify some form of notice. What do people need to know? Like, what resources should they be looking at? What are the main parties they should be looking to deal with? I mean, I know I've gone through the N4 process and then the one that comes after that, and I've issued, I believe, N11s, and I've been through some of them, but generally, I mean, I've had really good experience with my tenants. I haven't had to deal with it, but I know not everybody has that experience. So can you just tell us high level, what parties do we need to be aware of, and where do we start if we're having problems?
Right away is the communication, trying to figure out, is your tenant actually working with you? Do they want to work with you? And if so, you need to work out that payment agreement. You need to get that payment agreement. You need to show proof to the adjudicators that you are trying to work with that tenant, because that's going to be the major factor when you actually get in front of a hearing is, were you able to work with your tenant? Show us how you've tried to work with your tenant, and that's showing the means of trying to work with them. When you give them a payment agreement form, and let's say they fill it out, great. But if not, let's show that you have a track record of trying to give it to them and them refusing to do it. I like to give a little extra. So as I'm trying to work out that payment agreement with them, I'm also guiding them to different government services that help landlords with their rent relief. So there is programs out there. A lot of us were really upset at the fact that we had commercial relief for the commercial landlords through the pandemic, and nothing really was happening for landlords. We just had eviction ban after eviction ban, but there is actually, different service managers across the province that can indeed help tenants with rent arrears, as well as a relief from utilities. So it's about educating our landlords on those programs and sending that information to your tenant, also documenting to show that you're trying to not only work with them, but you're guiding them to funds to help them. Now, if that tenant does not pay anything, not a single dollar towards their rent, you show that they haven't paid a payment arrangement, you sent them a link to government services to help them with their rent relief, you can now walk into that adjudicator and be very proud to say, I've tried, this is now financially hurting me. I've tried to guide these people. They haven't paid me a single dollar for rent, and I'm now looking for a standard order. And you always make sure, landlords, that you are getting your N4 application out the door. I know we have like, hey, something happened. I had a big expense. It's great. It just all depends on the manner and way you give that N4 notice. Saying, hey, I know you're going through some difficult time, but I do have to give this paperwork. But, once you pay, and by the time you're telling me you're going to pay, don't worry, this application's out the door. I don't have to file it. It's about still working your paperwork. It is a business, and you need to have them familiar with these paperwork, because when you do obviously have these tenants now abusing the system and you start giving these forms, it's going to be a shock to them, and then they might retaliate in a different way. So always making sure that you're getting the FOR and read the landlord and tenant board. Read it like it's like the newspaper. That's the best way for you to really understand, because even though we're telling you to do these forms, if you do one thing the wrong way, your application is thrown out and you have to start the process all over again. And with a backlog like we have in Ontario, you don't want that.
In other words, read the forms carefully. And I know, like the N4 form, I've done a lot of those. That one has clear instructions on it, but I've made so many mistakes on those forms. Luckily, like, it never went anywhere. The tenants always ended up paying, but I look back at them and I'm like, wow, if this had ever gone to, a tribunal, I would have just got thrown out. Fortunately, most tenants, they're just scared by the form and they want to work it out. So, but I like the point you made, talk to them, say, hey, this is a formality. I have to do this, but it's not a big deal. I want you guys to, get it up to speed. So even if the tenants have the best intentions, do you recommend still do the N4 no matter what, if they're late?
Always.
So
always.
on the second day of the month, if you don't have the money, you're doing an N4?
I usually say the third, especially if it's just to the concept that you got to see their pattern. Are they the type of person to say, hey, rent's early. Hey, I'm going to be a couple of days late. You start to know their pattern, and being able to give that N4, but it should be a mine instead. I say no more than the 5th of the month. Because you already have a 14-day delay in before you can even file. And then you have your hearing delay. And then if they delay it because of the loopholes that tenants know, now you're even looking at more delays. And let's not talk about the sheriff. So, every day counts, but if you have those means to deliver that notice and making sure that your certificate of service is just as clear as your N4 notice, because just because your certificate of service form is a way to state how you serve that tenant, you got to make sure your paperwork is right there, because your application could be thrown out the window just because of the certificate of service. So it's really challenging to make sure that your forms are proper and that the landlord tenant board is changing all of the time. So just because you printed off like multiple forms all at once and you're going to grab it from your file, making sure that you're double checking it at the landlord and tenant board as well.
Yeah, good point. I know I've gone on there and couldn't find the forms because they were updating them. So they're back up now, are they? All the forms are back on the website?
There's going to be more changes.
Yeah.
And you know what? This is good. When I started advocating, we couldn't get a change for the life of us. So change is good. And just making sure that we're a part of that change.
Yeah. So for anyone who's wondering, my experience with these forms is that you can read them, and if you take your time, you can fill them out correctly because the instructions are there. Would that be your take as well? All the forms, including the N4 and some of the others?
They're all there, when you get to an N5, let's say you're N8, so if you're looking on the concept in N4 and you're always given these N4s because it's business, it's protocol, but sometimes it also means something else. You may not be just given the N4 because you want that tenant to know, but you also can lead into, okay, we have 12 months. I had to give you 6 N4 notices. I can't run my business like this. We need to make sure that the rent is being paid on time. So now you can actually apply to the board with an N8. And the only way to do an N8 is showing that you've showed proof that you've served at least 5 and 4 applications, and sometimes 6. It all depends on what adjudicator you have. There's no consistency with our adjudicators, and their information of which adjudicator you're going to be getting. You can look them up and see what their background is. So that's a tip for our landlords too, is that when you're checking to know what adjudicator you have, you can get their bio, see how you can address your situation to fit where they come from, and see if that could help you. But sometimes you get the counselor past deputy mayor of Ajax denying your expedited hearing. So that sucks, but what can you do?
Yeah, interesting tip. Yeah, look into who you're going to be dealing with. I think that's that makes a lot of sense. Okay, so I think we'll get into a couple of these questions. I'm trying to gauge just where people are at generally. So everyone, if you're watching, if you're listening, let us know. Are we asking the right questions here? Is this right down the middle for you? Do you want us to go back into more of the basics, or do you want us to keep moving this forward? I guess there's just the one thing I'll add is go to the Landlord Tenant website, just like Kayla is mentioning. Understand the forms that are there and what they do. Even if this is over your head right now, it will get more clear, especially if you go to the website and you investigate those forms. But just before we get into these questions, so if someone's got a tenant that hasn't paid in 6 months and they've been trying to get them out, what are their odds of getting them out in the near future right now?
Well, I do find like the time frame have sped up. I've helped a landlord do their application for the regional Waterloo, so to speak, in May 11th, and they now have a hearing August 16th. Before you would apply in May, and we might not get one until May the next year. So it's improvements. It's definitely improvements.
So if you got the hearing in August, is that this is the hearing after you've heard the N4 and then the N5? Is that right?
So let's say this is actually, for this in particular situation, is going to be an N12. So the landlord's trying to sell the property, the tenants are refusing to move out, and the tenants are actually asking for $20,000 in order to move out, to make this deal go through. Luckily, the seller has a buyer who is very patient and is waiting, but obviously they're couch surfing until they actually can get in to their purchase, the property that they just purchased. So as they got this hearing for August 16th, and that is going to be a hearing where the tenant and the landlord get to show up, they get to vouch why the landlord is going to say, I need this place, and the tenant's going to say why I don't want to move, or to say that, I'm going to be homeless, or that they are going to be paying a lot more rent elsewhere that they can't afford. They're going to try to get it delayed or refuse. So sometimes our tenants are now pulling Section 83, where they ask the adjudicator to delay or to refuse the eviction. So that's a tactic that the tenants work with, and of course their legal representation. So it's always something that our landlords need to be prepared for when they vouch that they need to sell it. And I could see the adjudicator would probably do more delays versus refuse, and just give the tenant more time to relocate.
Yeah, that really just doesn't sit well with me, that they would stay. But I mean, I get it is what it is. So say for instance the adjudicator said, no, you have to leave, and leave now. And could you make an application to the sheriff with that decision and have them come out to the property? And then how long are you waiting for that?
So right after you have your hearing, and let's say that they let you know at the time of hearing what they've decided. Some of them don't, because it's public. A lot of tenant activists and landlord activists are on there paying attention to what is being done. So they will say our judgment will be in the mail, or it'll be in email. And then you have to wait for that. So some landlords are waiting 30 to 60 days right now just to get the paperwork. And you can't do anything until that paperwork comes to you and it's officially stamped with the date in which it was created. And then you have to count the time frame on that order where they give you a date for the tenant to leave, and then at that time frame, then you can apply for the sheriff and then put yourself on the list for the sheriff to come, and you can know that with an eviction ban that was in place and orders still happening, hearings still happening, that there is now going to be a bit of a backlog. I'm hearing approximately 5 weeks for the sheriff in order to evict.
And this is getting better, but we're still, if you have a belligerent tenant that's just trying to be difficult, it could take 5-6 months even still now if it's happening. Is that a fair assessment?
Definitely. And you know what? Like a lot of us landlords, we use this trick, and I don't recommend us doing it anymore. It was cash for keys. You know, we always said, let's do cash for keys in a way to skip the landlord and tenant board. I rather just offer them a good chunk of money, but sometimes the chunk of money is not even worth it to them. It used to be like 2 months of rent, 3 months rent, you know. Once they introduce that 1 month's rent that you have to give for an N12 notice, that's when it seemed like the expectations for tenants had escalated, and they want more and more money in exchange to leaving their unit. Because a lot of it, they talk about rent evictions. They talk about the concept that landlords are just trying to get these people out in order to get the rent up. But knowing some landlords are like, no, I just want a nice tenant who pays on time, who keeps the place clean, and I need to make my numbers work. So this is where we used to do it. We don't advise it anymore because obviously that information got to our tenants. And now the tenants are like, I want $20,000. And they will hold on. They will make your deal sink before they want to leave. And that's we got to stop it. We got to tell them we're not giving out cash or keys anymore.
Yeah, it's a bad trend, right? The word gets out. So vet your tenants, like do your research, call every reference they have, double check the landlords, the previous landlords. I would actually go in and confirm that the previous landlord actually did in fact own the property. You know, don't leave any stone unturned. And then of course, trust your gut. This is my take. Of course, I'm not giving legal advice, but this is my take and how it's worked for me to avoid situations. I've had bad tenants, but usually going in with reason and kind of explaining how things will happen. You know, I don't want to have to take you to court. I don't want to have to do this. Let's work together. That's worked for me, but I know that I've heard so many horror stories lately of people really trying to abuse this, which is unfortunate. So let's go ahead and get into some of these questions, and I'm sure that's going to give us a little bit more of a direction as to where this episode is going to go. But okay, so Jacqueline Marshall, I hope I'm saying your first name right. So security deposits are not allowed here. What legal inclusions can I include in my signed lease? And for example, can I say if you clog a toilet and create damage and cost and the cost of a plumber is on you? Oh, the cost of the plumber is on you, not me. And what else can I legally include to protect myself?
Well, definitely having a security deposit is obviously something we always wanted in Ontario, but we have first and last. Meanwhile, it doesn't really make sense here. It's not like Alberta. Alberta is really investor friendly, and you can tell through the way that their justice system works. And then when you talk about the toilet and what we use for our additional terms, and that could be more of like, if you can show inside of your additional terms that if something by accident, totally, us as a landlord, we pay for it. But if you've done it where it's on purpose after the first time, this is where, you could start making them responsible for the damage of that in particular item that they've damaged, because of the concept that it was fixed, it was in working condition, and if they constantly did it because they were neglectful, you can actually issue your N5. Now, mind you, I am just a landlord who's been doing this for quite some time, but I am not a paralegal. But you will have success in making sure that you show the track record of the abuse of doing damage, and it's been done on purpose. After let's give an example of flushing things down the toilet. We told you in a letter this time and this time not to flush toilet stuff down the toilet. You have failed to act on our request to prevent you from doing that. Now we're going to be issuing you an N5 notice to end your tenancy. And then that is if they don't correct their behavior within the 7 days, that is when you take them to the landlord and tenant board and have it dealt with in front of the adjudicator, where the adjudicator could issue an order to the tenant in order to refund you what you've been paying. So it's really utilizing these and these notices, all the N forms on the landlord and tenant board website, and trying to read them and see what is fitting to your situation. But usually you'd be able to handle this with the landlord and tenant board. And again, sometimes we just have to be understanding and go, yeah, sometimes it's a mistake. Yeah, they just broke the window. That sucks. Yeah. It's at least, you have something for your tax write-offs, right? So we all need those now these days.
Yeah, I mean, I actually take that approach with tenants. Like if it's just a little something here or there, I try not to nickel and dime them. There's good cash flow in the properties that I have, which it just made it a little easier to look the other way if they're generally reasonable. And then every once in a while something happens. Okay, you know what? I'll help you guys out. Like, and that give and take goes a long way in my experience. If the tenants know you're reasonable with them, they try and take care of the place. They don't try to do anything vindictive or destructive, which has been really good. for me. Don't mind my dog.
He's
Okay.
upset about it too. What do you want to N5 on the dog situation?
Yeah, we might need to. Okay, we have Colin Key asking how to deal with divorces. So they may present okay at the start and then things break down. So I'm assuming Colin is referring to a couple in the property, maybe one of your rental units that is getting divorced. Do you have any thoughts on that, Kayla?
Honestly, I try to keep them completely. You want to be involved because you want to know who's staying, because that's usually sometimes when you have that bad tenant. It's a good relationship gone bad, and that's where I had my experience. I've been doing this for 18 years, and I've only had to bring one of my tenants personally to court, and that was because I got stuck with the guy. The wife took off with the kid. I got stuck with him for 7 months, and it's like, damn it. But the best way for you to do it is try to figure out what they're deciding as a couple. Who wants to stay? Who wants to go? Who, maybe hopefully both of them want to go, and you can start all over again. And that would be the ideal situation, to make sure that that the rent is not so high that that one person can't cover it, and now you have yourself in a delinquency situation. But I would definitely try to mediate the situation with trying to figure out who wants to stay, who wants to go, but really encourage them to potentially both give notice, so that they can relocate and find something cheaper. But because of the market being what it is today, a lot of people are staying on to these units, and especially if the rent is cheaper, because they know it's going to be difficult for them to find. But ideally and then if not, whoever wants to leave, getting them to sign that N11 to state who is leaving and getting them off the lease. That would be ideal. But again, you got to really try to stay out of it as much as you can, just because with relationship breakdowns, it can get dicey.
Yeah, I like that answer. I've had issues, like domestic issues in my student rentals even, and I've had, tenants who have subletted to other tenants, and then they've subletted to somebody that they really shouldn't have. And they're calling me saying, "Oh, our sublet is doing this." I'm like, I can't get involved with what you've done, in a sublet agreement. You need to call the police if you have an issue. Like you need to deal. I actually tell them, and whether this is right or wrong, I don't want to see their sublet agreements. I actually don't. I just want the contact info. I said that's between you and your sublet. We have our agreement. Everything's between you and I. I don't deal with your sublets except for notice and things like that. I like to stay out of it. I think that would be my take on the divorces as well. And I want to stay out of it. You guys, as long as you guys are paying, that's great. If you guys want to talk to me, I'm here. But you got to handle it between the two of you. And yeah. Okay, so let's keep moving forward. Jake
Hopefully
Novus.
Answer your question there.
Yeah, I hope so.
Don't be a Dr. Phil.
Yeah, by all means, feel free to ask, to further clarify if you want more there. Okay, so Jake Novus asking, I am currently trying to get a tenant out that hadn't paid rent since March 2020. So my condolences, Jake. At that time, I filed for eviction, and we finally had a hearing with an order in May 2021. However, the tenant filed for a notice to appeal after that, which has now delayed their eviction somewhat inevitably. Any recommendations on how to deal with it and what to expect?
Okay. As soon as I'm like, okay, March 2020, did you have your hearing? Okay, May 2021, you had your hearing. Okay, through that May 2020, was the adjudicator siding with you? Were you getting the order of an eviction for non-payment of rent? And that's when the tenant put a stay. And do you have your next hearing date for that stay? Now, the good news is technically a tenant can only apply for a stay once through their tenancy. So just to know that when you finally do get that hearing because of the stay, just know that that could be the final straw. Now, when I say that could be the final straw, technically, like I said, one stay per tenancy, but sometimes we have tenants who actually get 2 or 3. And that's because, no secret here, Landlord and Tenant Board cannot have a system to try to keep track on these stays. So if you do see another stay, or hopefully they just don't apply for the divisional court, and that is another something that is going to even prolong the eviction even more. So that is the concept where we don't really talk too much about, because it's just another loophole within the system where they actually get to stay until the case is heard at the divisional court as well. So best thing is that just still go with your strong voice of, you know, why are they applying for a stay? Because that's what we're trying to advocate for as well, is that if a tenant does apply for a stay, there should be a reason that accompanies that before it gets granted. But right now they automatically grant that stay. And this is the concept where we really want to find out why that stay is being granted, just so that you can now prepare for the hearing to kind of have the rebuttal of why they shouldn't be granted a stay and that the eviction should be lifted. But good note is that if they do side with you after that stay hearing, is that you're now got that paperwork and you can go and apply for the sheriff right away. So that could be a good thing.
So a couple of updates from Jake here. He said they did get the order for the first stay as it is going to the divisional court. And then he said he missed, or he applied for a stay because he missed the hearing. And he says, thank you.
How much money is this tenant in the arrears?
Jake, are you still with us? How much money you're waiting on? About 10,000.
10,000? Yeah, this sounds like a professional tenant, because normally what happens when if you missed a landlord and tenant board hearing is that you can apply for your stay and you get another hearing. But if they're gone to the divisional court, that means they've already had that time in court, and now they're now trying to prolong it by waiting for the divisional court. I think the best way for you as a landlord to better protect yourself, because you're just going to have to ride the system. There's not going to be a way for you to get over this. You just have to go through this nasty system that we're in, but making sure that you're reporting this tenant to Landlord Credit Bureau, reporting those monthly payment histories that they're missing to Landlord Credit Bureau, so that it not only just goes to Landlord Credit Bureau, but it's also going to affect their credit. And it's going to affect their credit. So when you do get this eviction, that it's going to be on their record, where other landlords who are doing credit checks are going to be able to see this through an open trade line from LCB because of this report. Because I could tell you, from when they know the divisional court, that's it. You got yourself a professional.
Okay, so we had a question here about that. Are there resources to identify professional tenants who know how to play the court system? And that was a well-timed question. So
I'm not even seeing the question. I just me and Andrew here on the screen, just so I can keep myself from looking up. Yeah. Every landlord in Ontario and every good tenant needs to be registered with Landlord Credit Bureau.
How do we do that, Kayla? Where do we report that? Are you still with us? I think you might have froze on me there. Okay, guys, Kayla. Okay, oh, there you are. Okay.
Am I back?
Yeah, you're back. How do we report to Landlord Tenant Bureau?
Okay, so Landlord Credit Bureau, you can go on to landlordcreditbureau.ca and you're going to be able to get yourself vetted. So they're going to vet you to make sure that you are who you say you are. You can have a free account, which you can utilize their platform for record keeping, or you can have their premium account. So their premium account, it's $199 for the year, or it's $19.99 per month with 60 cents per lease. So you can have 5 people on the lease, you still only get charged 60 cents. But if you use the code OLW15, you can actually get 15% off your monthly membership with Landlord Credit Bureau. And this is the power that's behind it. So as your premium member, you're going to be able to have your tenants are going to receive a welcome email. So good or bad, they're going to be able to report the welcome email to inform them of what Landlord Credit Bureau is all about. And then you have the concept of consent. So a lot of people think, well, do I need the tenant's consent? Do I need a judgment? Do I need an order? And you don't need an order or a judgment to report your bad debt. And you don't need the tenant's consent to report a bad debt. But if you do want to report your tenant's good payment history, you will need their consent. And you can do that through the clauses that are available on landlordcreditbureau.ca's website. And you're going to be able to do it through the welcome email that the tenants will get as you make a tenancy record for them, and they can opt into that service. And you're going to really utilize this program and this service in a way that's going to help you with your screening. This is what I love about it. I get excited for it because of all the years that I've been advocating, is that when you're putting your rental unit up on Kijiji, Facebook, you're going to put in there that you are reporting to Landlord Credit Bureau and that you are going to be doing a tenancy search through Landlord Credit Bureau. So every landlord, if they had a bad or good, if they were doing that tenancy, putting their data into the system, your tenancy search, you're going to be able to pull up that tenant's payment history, and you're going to be able to see the 6 questions that were answered by the previous landlord and a description of their review. And most importantly, you can actually see the landlord's name and their email address who actually put that inquiry on that tenant into Landlord Credit Bureau. So you can actually connect with them to know you're actually speaking to the landlord for that reference. And it's going to start to get utilized where I, as a landlord doing my screening, I'm going to be like, hey, can you give me a reference from your previous landlord? And they're going to like, oh, you want a letter? Do you want them to call you? And I'd be like, no, I want them to sign up with, register for free on Landlord Credit Bureau. They can put a review with your consent. And then I'm going to be able to see that review to know that I'm actually getting the landlord. So this system, I call it the game changer. It's the game changer that's going to really bring that justice and fairness into the rental housing community. It's going to reward our good tenants and help them build their credit so that they are successful homeowners or landlords themselves. And it's going to put that consequence that's in place for these tenants who think that they want to continue to keep abusing landlord upon landlord, because we have more landlords leaving the industry and then coming into it because the risk is so great. LCB is limiting that risk for us, and that we're becoming that united voice. So that's why I'm proud to be that national ambassador for them, because I see what I've been doing for landlords for the last 10 years, and I'm going to spend the next 10 years doing this and informing as many landlords as I can about it, because it is going to be the game changer.
It's a fantastic idea, and I think that it has a lot of potential. I don't know where it's at because I haven't actually used it myself. But my feel on that would be that it really is about how many users are on the system, right? Once we hit a critical mass of people using it, then it becomes extremely useful, right?
When you get yourself into a tenancy search, wanting to know how many tenants are in the database, that's where we get tenancy search. They're going to be offering their credit checks that are going to be obviously through pulling from Equifax. You're going to see the full on credit. But the most importantly part of Landlord Credit Bureau is not just how many people are using the database, is knowing that you as a landlord can automatically affect your tenant's credit. Yeah. You're letting other tenants, other landlords who are not using the Landlord Tenant Board service, you're letting them know that there's something to look out for here with this tenant by able to be reporting their monthly payment history. So that's where you think that it's all about the data. So when you look at other places that report that monthly payment history, you want to know, okay, how many people, but they're not reporting to the credit bureaus. They're not reporting to Equifax, and that's what gives it the strength. And when a tenant is knowing that they get an email, a welcome email, a rent reminder email, as well as a rent collections email coming to them of showing how it's affecting their credit by not paying their landlord, that is the power. Like I said, when I had that one tenant that I took 7 months to get out, less than 24 hours, he was already gone for 7 months. And in less than 24 hours, he was calling me. Our landlords in our group, they have their tenants squaring up, making their payments because they know this is now going to become the new norm based on what COVID has done to this industry.
So to clarify, Landlord Credit Bureau is its own system, but also reports to TransUnion and Equifax, so you can see a monthly payment history.
Equifax right now, TransUnion in the future.
Gotcha. Equifax is I think it's more common, but yeah. Okay, so that's extremely useful. I'm just going to give my personal take on this. Has been my strategy, and what kind of helps me sleep at night is just posturing how I would do things. Like if a tenant's being difficult, just explain simply to them that, like in the case of Jake, if you've got $10,000 owing to you, I would make it very clear to that tenant that I will be collecting on that. Now, whether you delay this and, stay another, 15 months, I will be seeking a judgment, and I will be seeking to collect on that judgment. I think there's 8 different ways you can collect on a judgment. You have to pay like $100 for each one you want to do. My lawyer friend told me this. I'm not a lawyer. I'm not giving legal advice, but I would just say I would do all of them. I'll go after your bank account, go after your wages, and actually garnish your paycheck. Like, I would just say, look, this is my process. This is what I would have to do. I don't want to do any of that. So how about we just work this out right now? It's better for you. It's better for me. It works for everybody. Let's just work this out. And that's been, at least taking that approach, I feel like it's disarmed some situations, saying, look, I could do this. And we both know I could, but we don't want to go there. It's not good for anybody. And I don't know, like that's not going to work for everyone. Everyone has to find their own voice in how you talk to your tenants and posture and set up the situation so that you don't have to deal with these situations. But then, of course, get everything. Like on the application, Kayla, are you getting where do they bank? Who's their current employer? Show me proof. If you have this stuff, I had one tenant, they tried to move out in the middle of the night. They were trying to stiff me on rent, but I just said, okay, they didn't care about their credit. They didn't care at all. And these had been in since 2012, start of 2012. So this is when I didn't really know what I was doing. I put them in there and they were difficult tenants, and I had them until like 2017, 2018. And I remember calling them out on it. They didn't care about their credit. They didn't, none of that mattered. But the second I said I was going to go after their paycheck, he went silent. He said, let me call you right back. They agreed that they were going to leave the house in 8 days, and they were going to make it neat and tidy so that the new tenants could move in. And so this is why I think what you do is so great, because if you can help people to understand what their recourse is, then we can proceed with confidence in talking to our tenants and saying, look, we don't want to go down this road, but there is a tool here for us. And even if landlord tenant board doesn't agree and our adjudicator doesn't agree, we can still go to small claims court for the amounts owing and get a judgment. Is that correct in your understanding?
Yeah, it's great, but sometimes if you look at the difficult people that we deal with, they don't really quite almost have that good job, right? And they, like you said, they didn't care about their credit. This system is also with LCB is that it's informing the other landlords, because they're able to continue to keep doing it because the landlords are not getting educated on what products and services are out there for the credit check or for the tenant services. So you got to look at, can their wages be garnished? And then we got the concept of skip tracing. Now we have to find them. You have to know where they bank, and then you have to learn how to serve them. So when they do relocate and they are in a different place, it's like, okay, how do I serve them? Do I serve them at their work? Are they still working there? So many people, like I've had this one tenant that I know of who had 7 jobs in 1 year. So it's like, okay. And then you have tenants who have multiple bank accounts. And then as soon as you have a check that, say, hey, your payment just came back this month. Oh, I forgot to put money into that account. And it's like, why do you, what? Because that's like their play account. They don't care they're being charged multiple banking fees, but it's always going to be to the concept of utilizing to say, listen, it is true, I'm going to go after you in the court because you don't know if you can or not at times, but saying it actually can help. But knowing that you're going to prevent them from securing their next rental unit because you're telling them this thing is spreading like wildfire. The landlord, the rental community, the good tenants are supporting this service, and you're going to be left in the dust. And good luck waiting for rent geared to income or government housing, because that waiting list is longer than you can imagine, right? So it's about saying, listen. And I have a situation, we have a tenant where they're bossing you around trying to think that they're right, and it's like, I have a lot more tools to deal with you. So if you want to continue to keep this battle going on, it's one thing, but you need to start looking at different services, different products, different ways of communicating, and you have to keep it very professional. And if you feel your emotions are being attacked where you want to just punch that person in the face, learn to step back or hire someone personal. Because I know with my own units, it's hard. Your heart starts pumping. But when a property manager, you're in and you're professional and you're calm and you're collective and you know what is right and what you need to do. So just take that and just, because how many articles have you seen, Andrew, where the landlord's been getting arrested because of they're going after their tenants, and the tenants are saying things. So everyone stay calm.
You got to stay cool. Yeah. You got to stay cool.
Rent on.
Don't go breaking into your own unit because you don't think the tenant should be there. Yeah, you can get yourself in trouble.
Or taking away their door.
Taking away their door, changing the locks, those things sound good in theory.
Hydro, not worth it, guys. You got to go into the board with a clean conscience. You're going to go in spick and span, and that way you can hope to win your case.
Okay, guys, just a quick reminder, make sure your questions go into the Q&A. I'm working through them. We're going to try and kind of bang these off, pretty quick here so I can try and get to all these questions. So Jacqueline asked another one. What are 5 tips or questions to help screen a tenant? I give an application first and check the information first and proceed from there. But what are some pre-screening tips?
For me, I act very cool, very chalant, almost act like an amateur, like you don't know what you're doing. That is the best tip I can give someone, because it's more of the concept where you're going to try to get to know them on a commercial, like as a character check and a friend basis, but you got to It's not going to be really that friendly. So when you're walking in, you're letting people see like, hey, you know, come on in, you know, this is a 2-bedroom, 1 bath, you got the backyard over here, you got the garage, you are responsible for, you know, the snow removal for your in particular property, and say, so have you guys seen a lot of places? Like, what are you seeing out there? You know, getting into the concept of working them as a very casual conversation, like you're just there to show them the unit. And then you can get into that off topic of trying to figure out, you know, oh, why are you guys moving? You live in town, and you're just doing it very friendly. Sometimes when landlords are doing their screening, they have it where it's a, hey, so why are you moving? Like, do you want to go here and work in this area? Like, are you okay with payment? Like, you have to get yourself into that friendly thing. Just like I talk to a landlord now or a tenant and be like, oh, you know, I just forgot to let my dog out. Oh, I hope it does not pee on the floor. I'm going to be so mad. I don't have a dog. But they're going to tell me that they got one, you know? So it's, and knowing that you're inside of your relationship, you have a relationship, that's great. Now you're going to ask them, it's like, oh, my husband, oh, I don't know how I'm with that man for like 18 years. He just texted me this. And they're like, oh, do you have a spouse? You know, it's really getting yourself into and getting to know them as a person, and then let the application and the paperwork speak for that. But never take their credit check. I don't know how many times I tell landlords they are getting forged really, really well these days, where one almost bypassed me. So the tenants are really doing their own credit checks, saying that they're doing their own credit checks, so don't taking that, and getting into the concept of asking that person what they do in their job. You know, when they say that they work at this job, is like, oh, how is that? You know, what do you do there? You know, what about this? Because you're just showing your interest on the concept that you want to know what they do, but really you want to know, hey, do you really work there? Do you know your stuff? How long have you been working there? Because I want to know, do you actually know what you're talking about? And are you just making it up? Because I am going to be asking for your work reference from your place. So there's going to be lots of different ways to get that tenant into talking. But it's just, I hate the one line that landlords usually recommend is, tell me about yourself. It's like, nah. It's, you got to feel them. You got to really pull it out of them to tell them about yourself. Just telling them, tell me about yourself. Well, I'm quiet. I have a job. I like long walks on the beach. No, they're not going to tell you the truth anyways. They're going to tell you what they want to hear. So it's really about reading between the lines when you're doing your tenant screening.
Yeah, being casual. And just a note, my buddy taught me this one. Just when you're casually talking to them, I don't know how he slipped this in, but he'd occasionally just ask the tenants, "Oh, you know, when's the last time you got an N4?" Just kind of slipped it in there. And if they answered anything other than "What's that?" then he's like, "Oh, okay, these people have had a history of paying late." You know what I mean?
They told me that they've gotten evicted. Like, I've gotten tenants telling me, and I'm like, my partner with me, like, how did you do that? I'm like, I'm just acting like I'm the person showing the place. You know what I mean? Like, I'm just showing it. Like, so, like, have you had other landlords? Like, how they've been? Oh, this one landlord, they tried to take me to court because they thought I did this. And it's like, really? Are you serious? That's what happened? What a you know, and then they tell you more because you're showing that you're agreeing with what's going on with them. So, you know what, we don't mean to be like this. We don't want to be fake. We want to be truthful, but you know what, you are giving the keys to someone who can stay in your unit for at least a year, not paying rent, causing thousands and thousands of damages. You need to make sure that we are upping our tenant screening. And I think COVID really taught us that, to make sure that we are getting the right type of person, because this is going to really influence our elected officials to pull up their socks and realize that they've broke the system and it's almost beyond repairable. It's becoming our play field where we will pick and choose, and the people who we're denying, they will be the problem of the province as well as the taxpayers. So you can choose to work with us or work against us, but we will be tightening up our screening to the point where not a lot of the people who are being denied their first-time homes, they're the people that are going to be getting the first dibs at these rental properties now. What's sadly because of the new changes with the stress test.
Yeah, there are good tenants out there. For me, I want to weed them out. So what I do is I actually will send people, anyone who inquires, like I'll post on Facebook Marketplace. If they inquire, I have a Google form or I use Jot forms, send them over, and it's a bunch of pre-screening questions like, why do you want the place? What do you do? Like, you know, why have you left your old place? You know, how much money do you make approximately? Like, just some of this stuff that would be in the application. I'll do that before I'll even show it to them. And I like to add a couple of hurdles in there, because if they're not willing to take the time to do those hurdles, then they're probably the type of person that I'm going to set up an appointment with to come see the place, and they won't show up. So I've really compressed, when I do these showings, I compress the amount of people coming out by taking that procedure. And I'm sure you've done similar stuff like that as well.
Bring two people, one outside, keeping them entertained, talking away, you know, keeping them company while I finish up with the people inside, so that as they talk, as my partner talks to them and then I get to talk to them, then you and your partner now come together and say, this is what they told me. Did they tell you this? You know, that, and then you work that concept of what's a lie and what's a truth, right? So it's a great tactic that I love using, and it hasn't failed me yet, knock on wood.
Awesome. Well, there's a lot of different ways to do it, right? Like, as long as you're getting, you know, you're understanding these people. And I think pre-screening is everything. Like, if by the time you're dealing with these $10,000 issues that you made the mistake, you know, a year before, and you know, that sucks, but we learn from these, and I've made these mistakes too. And you just, the key is don't do it again. Don't do it twice, or learn from our pain.
It's the job, right? People say, like, look at the job. And now with COVID, now you see someone that's applying for your job and they work in the restaurant business. You're like, oh God, like that used to be really good money.
Yeah. Okay. So Dave's asking about some pre-screening questions as well. He says, I'm in the process of renting a property. I have pre-screening questions for potential tenants. Just from the answers I'm getting, I know right away I don't want to rent to them, but they keep asking me when they can see the property. What is the best way to approach this question if they keep bugging you, knowing that you have no intention of ever renting to them? That's a good question.
You know what? For me personally, I don't dabble with this one. This one's a very scary spot where you're denying someone before you even get to kind of look at, you know, what it is. I literally open it up 15 minutes apart. You're having to have multiple days. Sometimes it takes me 4 straight days, 4 hours each, doing 15-minute intervals of interviewing people. Even if you don't want them based on what they say to you, then it's really, it's not worth the concept of, you know, a human rights case coming against you. So it's best just to try to get as much information about them, but still book them in. It's a great way, because you never know. Sometimes they could shock you. You know, maybe the paperwork is not the greatest, but getting to know them as a person, you could be finding a really good tenant there, and we're just not giving them the opportunity from seeing them at firsthand.
I actually heard a story about this in Florida. There was one of the property managers there. They had a potential tenant reach out to them who had been charged with a crime but not convicted, and said in the email, I've been charged with this crime. Would you consider me for a tenancy? And they just responded, no, I don't believe the owners would be agreeable to that. And they got hit with a lawsuit, and it cost them $5,000 just for that response. They were just the property managers, and they got hit with that. So I don't know if that would happen here. They were fishing. This guy was a professional. He was doing this everywhere. He was sending out these emails everywhere and just making money. So who knew? You get charged with a crime and it can be profitable, apparently.
Just like I'm on OW or ODSP. Are you looking at that type of application? There is people out there in Ontario that do fish and ask the landlords this, so that they can indeed bring a human rights case against you. And if you're looking at, you know, walking into your tenant's home with your shoes on and it's against their religion and getting fined $60,000, this is something that I'm not going to challenge.
Interesting. Okay, let's keep moving on these questions. Ian is asking, I'm a landlord. I'm entertaining taking on tenants who practice Airbnb arbitrage. Any advice?
Yeah, you might upset your neighbors in there. Airbnb, it's definitely obviously impacted through COVID. But you don't have to go with the RTA. You know, that's the benefit, where a lot of landlords were going from long-term rentals and getting into short terms because of the RTA and the LTB. For me, I'm hearing some success on it. It's more of about, you can have your good and you can have your bad, just with your good tenants. But for me, I'm a type of a long-term tenant person. Don't really like the ins and outs, because especially when you're dealing with potential bed bugs coming or cockroaches, it's a very costly and it's a really costly job to get rid of, and it could, you know, put you back a little bit when you do have to treat it, or you do have tenants now complaining about it. So that one's a little iffy for me.
Interesting point about the bed bugs. I mean, I don't know of them being that common in my experience, other than in New York City. I came across them one time, but I mean, yeah, it could happen. Anything could happen. For me, it's more about the reputation of the person coming to me. Like if they have a track record and they do a great job of this, I would be more likely to consider it, versus if it's somebody I have no connection to, they're not in my community. You know, I'm less likely. My mentality is anyone I deal with in business in any way, I want them to have something to lose. If they have a reputation, good standing in the community, that's really important. If they care about their credit, if they care about, you know, a number of different things, I want to know that if they were to do anything that wasn't above board, that it will come back on them. This is why I won't even entertain tenants that don't seem to have anything to lose, because what's the point? Why would I want that? You know, and there's plenty of those type out there. So
Exactly.
okay, we're keeping going here. So anonymous attendee, regarding Jake's situation, does the tenant still owe the landlord for the arrears? I'm not a lawyer. Neither of us are lawyers or paralegals, but I would absolutely be claiming the entire amount and going after the entire amount personally. And I'm sure there's many cases in the past that have worked out where that was awarded. I would assume you'd be on the same page with that, Kayla.
Yeah, this is about, obviously, that they still owe that money. They've utilized that place. They're probably still in that place. So it's definitely the concept of being able to get rewarded that money. Now, sometimes you could look at forgiveness, you know, and if you forgive anything, that puts it in just perspective. But yeah, it's that money. You got to make that sure that it follows them and prevents them from getting the next unit.
Mm-hmm. Okay, so we have another question here, Muhammad. What's your take on Bill 184? Any good stuff for landlords?
So obviously Bill 184 is the reason why I got into property management. I'm like, okay, I'm going to help these landlords out in the regional level, you know, to make sure that I protect them against these professional tenants. Bill 184 obviously upped the fines. So you went from 25,000 to 50,000 for unlawful evictions for individuals, and then from 100,000 to 250,000 for a corporation. Then you get yourself into rent increases. So normally for a landlord, if we didn't give a rent increase on the N1 application form, a tenant can dispute that and they can get the entire money that they've paid through the rent increases back, because it never was on that proper form. It wasn't served in a proper manner. They've now adjusted with Bill 184 that you can indeed still have the rate that you've charged that tenant if your tenant doesn't dispute it within 1 year. So that is something where if a landlord says, you know, your increase is 20, I charge 30, you've been paying that amount for the last 12 months undisputed, that becomes the lawful rent. That is something that of a good thing for our landlords. And same thing with the N4, the N1 application. So you really want to utilize the consent by email application on the Landlord Tenant Board website, so that you can get your tenants to give you permission to communicate through email, and an N1 application can be sent now to the tenants by email if you get them to sign this type of form. So that's a good thing. The other thing with Bill 184 is that the maintenance, you know, this is a big thing that our landlords were getting trapped in, where you have an N4 application and an L1 application at the board. The tenant is now coming to the board to talk about the non-payment of rent, but they go, wait a second, my landlord did not fix this, did not fix that, did not fix this. And now all of a sudden the landlord is very shocked to even know that there's even maintenance issues, but that could cause the adjournment of the landlord and tenant board. So you now have a delay happening because the tenant's bringing up maintenance issues. With Bill 184, they now tell the tenant that if they have any maintenance issues that they want to bring up at this type of hearing, they have to give it to the board 7 days prior to the hearing. And the landlords have 5 days, should be 7, but landlords have 5 days in order to respond regarding that maintenance issue. So that's another thing that seemed to be very beneficial. But again, it's changes, minor changes that we're looking at. Now, again, it is going to go with, the renovations. You now have to pay, you're paying tenants more money, even if they if they want the unit back or they don't want to have the unit back, you're still having to give funds to the tenant in order to do this renovation, or provide them with a suitable other accommodations to their liking. So, you know, again, little changes. I feel Bill 184 did come out, not because of the little tiny changes, but more of the punishment that is out there for landlords if you do try to do unlawful evictions for the N12 and the N13s. And they just gave us some little tidbits on the way. So that's the concept where I feel the province had created this in order to really discourage landlords from renovations and also, you know, taking it over for their own personal use and trying to get away with it. That's why the way that they've done it, I feel that the M13s will not be used. I don't find that they get used now, but I can see more landlords are going to not put the time and money into their unit, and we're going to be creating some slum landlords in some really slum places because we don't want to have to follow the protocol for evicting someone in order to get the maintenance that obviously these aging properties need.
Yeah. There's a lot to unpack there, and I want to keep moving here. Obviously, we could keep going there, but okay, I'm going to keep going into the next question here. Is it better to require tenant? I guess I'm just going to paraphrase here. Is it better for the tenant to have their own insurance or have them covered in our insurance? We have landlord upstairs and tenants live downstairs.
No, it's always about on your standard lease, you'll have the option where you require your tenant to have tenant insurance. I always click that box 100%. I tell the tenants you really should get in your own tenant insurance. It's next to nothing if you have your car insurance. You really should get it because of the contents of inside your property. If there was a flood, if there was a fire, we really want to have your property covered in your contents, or if you made a mistake, so my insurance company doesn't come after you. So this is a great way for you to get your own tenant insurance. Now, if they do it, you know what? I'm telling them that they have to do it. Can I check if they've, after the fact, and make sure that they have an updated tenant insurance slip to know that they're still current? Of course I can. If they don't provide it for me, can you apply to the board underneath an N5? You may. Look into that at the Landlord Tenant Board, but I would never put them underneath your own personal insurance, just telling them that they should have it. Check that part off on your standard lease in order to tell them that they should have their tenant insurance. And honestly, you get to see which responsible tenants we do get to have because they're telling you that they have their tenant insurance already. And that's another sign that you want to look for in a good quality tenant as you're screening them.
Okay, great point. All right, next one. Just purchased a property last February. Seller didn't forward or disclose info or standard lease form. Is it okay to ask tenant for identification, COE, etc.? And is it okay to change lease agreement if tenant agree?
Definitely, you can change your agreement if the landlord and the tenant agrees, especially if there's nothing in place now. I would just, and again, it's going to be out in the format and your character of how you're going to try to work this. Hey, I'm your new landlord. There's some paperwork that seems to not have happened. You know, these are the rules. Can we just get your basic information just in case there was an emergency situation? We know who to contact and we know who our tenants are, and then trying to get them into a standard lease. Put them in a month-to-month. Really don't encourage landlords to do a yearly lease. It doesn't do anything for the landlords. Certainly has more of an out protection for the tenants, but doing a month-to-month lease would be great. So just saying, hey, I just want to put you on a month-to-month. If you're ever going to leave, it's just a 60-day notice, but I do want to get some credentials, especially knowing their first name and last name and their date of birth so that you can report them to LCB and Equifax.
Awesome. Okay. Have you used Rentify?
I actually spoke with Chad. I'm excited to see. I actually have my next rental that's coming up. I'm getting to work with that. And I said, it's more about that. It's new. I love the concept. I love how it's another screening tool that I'm excited to bring to our members because of the fact that it does give us that ins of the bank account. Normally we get, hey, we want a 12-month statements or 3 months of statements. And sometimes you'll have your tenants like, oh, I don't want that. And again, they may shovel their nose up at the concept that they have to put their banking information into the system, a system that's new, a system that they don't know yet. And you could actually have a good tenant, walk away because they're not too sure what this system is. But I could tell you, I feel like it's going to be the new norm, just like LCB being the new norm. I think Rentify is going to be really helping us step up our screening game.
Yeah, that's great. I mean, we're going to need more tools. So, everything we can add in is hopefully going to be helpful down the road. Okay, as far as paralegals go, and this is a question I wanted to ask anyway, when, in your opinion, should a paralegal be used?
You really want me to say that one? You know what? I'm a really strong believer of getting our landlords into these community groups to really learn the system and help and get supported by other landlords and other paralegals within the group and learn for yourselves. Paralegals are definitely helpful, especially when you know you have a professional tenant. Sometimes having that paralegal step in and show, I'm not messing around now, I have a paralegal. So we've tried to work it out with you, and now I'm getting my paralegal involved because I'm at that point where I'm going to come over there and punch you. So we're going to get the paralegal involved. And even for landlord and tenant board, I feel that landlords and tenants should really be at the landlord and tenant board arguing their case versus having legal representation, because as taxpayers, we're paying for legal aid for our tenants, and landlords have to go ahead and hire their own legal representation. So again, I love my paralegals on one side of it, and then I like it when a landlord and tenant can battle themselves at the landlord and tenant board. So I have a love and hate relationship, I guess, but I have so many paralegal friends that I love and I would recommend. So if anyone does need a paralegal, just let me know. I'm sure I get one that will fit the job that needs to get done.
Okay, and that sounds like you sort of answered the question this gentleman had or lady had about, does it help to have paralegals serve notices? You sort of touched on that. I think that it does add a level of legitimacy, but I still like the person-to-person direct approach personally. Okay, so that's great. And while you're on the topic, where do people find you? How do they reach you if they want to connect and know more or ask for your recommended paralegal?
Yeah, so you can join on Ontario Landlords Watch members group on Facebook. When we have a few questions in there, like how'd you find out about us? Make sure you put Andrew on. Say that you heard us from Andrew. That's going to be very crucial for letting you into the group. We have just over 6,000 members, and we still have 2,400 people waiting to get in, unless I know that they're coming from people like Andrew. So make sure you put that in there, and I can get you in. You can also find me on Facebook with Kayla Andrade, which my photo is on your for your event tonight. So hopefully they can find me on there, and they can also email me at olwlandlords@gmail.com, and I'll probably be like, hey, let's get on a conversation, because I'm definitely more of a talker than a writer.
Okay, I'll see about putting some links in the episode notes, and that way people just have easy access to that. Okay, so that's awesome. We got time for a few more questions before we wrap up? Okay,
I'm good.
All right. Okay, so as far as references, Kayla, who are the people you want to talk to for a tenant?
Oh, so this is the tricky part. We always want to be able to try to talk to their employer. We want to be able to talk to their past landlord. And no matter what, we almost gotta cross our fingers and hope that we're actually getting the landlord. And that's where I feel that when you're getting yourself into getting reviews and doing tenancy searches and trying to find out where these reviews are coming from, even with LCB, where a landlord could actually leave the reference available there that could be checked. And that's another platform where we know that these landlords are vetted and they're actually allowed to report, and that it's going to be their past landlord doing it. And again, you just got to almost talk to that landlord. If you are talking to them on the phone, talk to them like the same lingo. Talk to them about the board. Get them off topic about that tenant. Talk about the Landlord and Tenant Board, the Residential and Tenancy Act, what they plan to do with investment. You can really tell which landlords and which investors are really on the phone and which are just friends of the tenant. But really, you're basing yourself on the concept of getting that work reference, a nice letterhead work reference showing that they work there, getting those pay stubs showing that they work there. We're honestly going in blind. So you really want to make sure that you're talking to as many people as you can, but don't take it like, oh, the past landlord said they were great. Sometimes we have our landlords that are in a desperate situation and they'll say anything just to get rid of that tenant. So always try to, read between the lines when you're even trying to talk to that past landlord.
Dig. Yes. Dig. Call them. I called the friends references on my last group of tenants. Like I called every number they put on that paper, and I just tried to get a feel. Like, are they weird people that they put down? Do they seem shifty? Can I throw them off guard? Do I get a genuine feel from them, or do I get the feeling that they're trying to, string me along and give me a line? And
Social
if you,
media.
yeah,
Social media, zoom up on the coffee
yeah.
tables, when you're meeting them and you're walking them out to their car, take a quick peek in, or they say that they have no dog, but they are covered in dog hair. I smell them when I walk in. It's like, okay, I don't care about you smoking weed. I just don't want you growing it here. That's the stuff that you really gotta get out of your comfort bubble.
Yeah. Just kind of, I'm sure this comes with practice though. The more you do it, the more comfortable you get with it, and it's easier to have these conversations. Okay, so Jacqueline had a question, and I think I'll just touch on it right now. So what hurdles do I have when she was referring to when I'm sending people for a viewing request. So if somebody asks me to see, I create like a free Weebly website. So if you go to Weebly.com, you can actually create a free website, and you can actually throw in a Jot form, like Jot form's free as well, of all the questions you want to ask. Or you can send them to Jot form or Google Forms directly. But I basically just created a website for my property, and I ask, what is your name, full name? What is your email? What is your phone number? What is your ideal move-in date? Are you okay with this move-in date? Yes or no? And I forced them to give me an answer. How long do you ideally see yourself staying as a tenant? And I actually put 1 year, 1 to 2 years, 2+ years, or this is our forever home. And I'm specifically looking, I don't necessarily love this is our forever home answer. And then how many people over the age of 18 would be living in the house, 1, 2, or other, and they can write it in. Any kids? If so, how many and what ages? Do you have pets? If so, please provide detail. I'm giving you all the things that I have in my most recent one. So does anyone who would be living at or regularly at the unit smoke? If yes, please explain. And are you okay with having only one parking spot? In this case, I only had one parking spot. Why are you moving? Please explain. Please explain your income situation. What is the total monthly household gross income? Please include all income earners and break it down. And is there anything else you would like to tell me about yourself? Those are my questions. And I'm sure, Kayla, you could critique that.
You know what? It's beautiful. It's beautiful what you created. The only thing I would ask is, has COVID affected your payment? Can you show proof that you were able to pay rent through COVID? We had a rent strike movement. Many people taking advantage of it. We need to show that even with, a hardship situation, that they were prepared for this type of situation and they were able to make their payments on time. And if not, they need to know that I want to see your payment arrangement. I want to see your payment arrangement with your landlord. I want to show that you're current and up to date, especially with the eviction ban being lifted and enforcement on the way. This is now like, get your spidey sense out, guys. Like, step up your screening a lot harder than ever before because of the eviction ban. At least when the eviction ban, our professional tenants were at bay. They now, this evil is now unleashed into the world, and you need to make sure that you are well aware of them.
Yeah. Okay. So that's a great one to add in there. That one was something I should put in there for sure going forward. So what else? Oh, just to cover that point. So that would be before a viewing. So somebody would have to answer all those questions before I would even agree to meet them at a property. And that cuts out all the tire kickers, the people who aren't serious, who are just going to stand you up anyway. You can do things the hard way or the easy way. I learned I stand on the shoulders of giants. I've had a lot of good advice from a lot of people that have helped me refine that. So unfortunately, I have probably too many questions here to get to all of them. So I do want to ask you, Kayla, you mentioned that you have some sort of tips and tricks, and I know you've given us a few already, but is there anything that we haven't covered that you would want to share with our viewers and listeners?
Related to what? Screening, to the landlord and tenant board, trying to get your house sold. I got lots of different.
Well, it's either screening or evictions, either or. What stands out as what we haven't covered yet?
I would say it's definitely about the open communication, right? Open communication. You have to document as much as you possibly can. I think if it's all about the management of the tenant. And I know that when we have a bad tenant in itself and they stop paying, your overall hurdle is going to be the landlord and tenant board. So getting to know all of the people at the landlord and tenant board and the adjudicators, and getting to know where they come from, you know, from their past jobs is something where it helps me when I need to expedite. So it's part of, if you are a landlord ready to get out of the industry, and or you have a tenant that is, you know, it's a safety situation, get familiar with the expedited hearing application at the landlord tenant board. You know, a lot of people don't know too much about it, but definitely expedited hearings. And if as long as it's fitting their niche regarding safety or illegal acts and or a potential hardship to a landlord, this could, you know, work itself into your benefit of getting your case heard a lot quicker, and making sure that you're not just sitting there and waiting, really getting to know the dispute program at the landlord and tenant board for you as a landlord in order to get to the higher up, especially if you're waiting a long time for a hearing, or if you're waiting a long time for your paperwork, your order to come in. And most importantly, every landlord, if you ever had to deal with a delay because of the landlord and tenant board, please make your complaint with the Ontario Ombudsman. And after you make your complaint with them, you say, hey, when is this report coming out? Because this is a broken system that, yes, we see some changes happening where it's going to be an accessible 24-hour day system that is coming from the landlord and tenant board. But we need help now. And because we have this abuse that's happening, and we need to keep ourselves going in this industry. You need to keep landlords, small landlords are 50% of the housing stock. And right now we're seeing that dwindle, and we're seeing it because of COVID, and we're seeing these homes of single families and condos and townhouses being sold off, and they're being sold for over 300,000 over asking price. Do you ever think that those places are going to be bought with the concept of being a rental in mind? No. So we really need to continue to keep your ear to the ground, and continue to hammer your MPP and really get politically involved, because if you're in the real estate industry, you got to not only have your network, but you need to be very heavily involved in how politics plays into this industry, and that will help you prepare to be a better investor for the future.
Yeah, you can't be rose-colored glasses about this. Have to take action. I think that there's so many things that applies to right now. Can't be a passenger in this game. We really do have to be active about it. So that's great advice. I did have one more thing that I just see here that I wanted to cover. So someone had asked about showings with the fear of COVID. What do you do if the tenants are in there? I mean, I didn't even give them an option. I just said, hey, I got to do a showing here. You guys don't need to be here if you don't want to. I'll make sure, leave the doors unlocked, leave the lights on. We won't touch anything. That's about what I do. I don't really give them an option, but what's your take on that?
So the tenants are still in the unit, and we want to do showings.
Yeah, they've given notice to leave. You got new ones you want to come in, but they don't want anyone coming through.
Definitely a hard one. You definitely don't want to cause any ripples. You don't want them holding on to the keys, and really they're gone into their new home, but they're holding on to the keys, so that you have to apply to the board to evict them based on the abandonment of the unit, and you're preventing you from re-renting it. So if you do have a tenant that is, hey, I don't want you in there, I would really try to say, hey, I'm only going to bring in the people that I am really severely looking at as a potential candidate. And I really, again, I won't touch anything. We'll keep the doors open, and we'll be in and out, and I'll make sure everyone brings PPE and sanitizer. But if you really see them pushing and they don't want anybody in there, honestly, guys, it's best about keeping it empty just for the month. It's just to make sure things are smooth, and that you're not going to lose multiple months by just trying to go rah, these are our rates. So yeah, that's my advice on that part of it.
Don't poke the dragon.
Don't poke it. Like they literally, I have a landlord, like the tenant had left and they have the keys, the utility is still on in that house. So you can't really poke it as, okay, this tenant has abandoned the unit because the utilities are still on, and they're just holding on to the keys because they're vindictive, and they know that there's a long wait for the landlord and tenant board, and they're preventing that landlord from re-renting out that unit.
Okay, awesome. Kayla, you are a wealth of knowledge, and everyone who's still here, let Kayla know how much you appreciate what she's done tonight and taking the time. I certainly do. There's lots to learn for myself, and I know the people here are going to have similar feelings. So I've already seen a couple of nice comments come through. So I really appreciate this. And for the questions we didn't get to, guys, I think probably the best thing to do is get into the group, get into Kayla's group, and post them there. because there's a huge community there, and it's not just on you,
Huge.
Kayla, to answer all those questions. We're going to have a lot more people that can help.
Oh, they're very supportive. We're there to help each other. We're here to build that community of the day-to-day operations and teaching you how to advocate and what you need to know, what tools you need to have that. And this is what we need to do to support each other. Because when I first started, we had nothing. We had nothing. And now we have multiple different support groups that can be there and helpful, but making sure that you got the right one. Because sometimes people tend to take some groups and turn it in more of a business aspect, but it's a free group to join. Just join in, say that you mentioned Andrew, I'll let you in. And of course, my information is there. So if you want to schedule a one-on-one talk, I'm always about that, because I need to get your feedback. We need to get that feedback so I have your thoughts and your process and your solutions being brought to the elected officials so that we can create a better housing industry that benefits good landlords, the good tenants, and of course our taxpayers.
Awesome. Okay, thanks so much, Kayla. We'll wrap it up at that, and I'll look forward to just staying in touch with you now that we've had the chance to meet and chat, and we'll keep this relationship going. And I know there's a lot of people we can help together.